After 40 years of marriage, I thought we had built an unshakable life together until she looked me in the eye and said 4 words that shattered everything. I want a divorce. At first, I didn't believe her. 40 years of shared memories, raising children, building a home, and planning our golden years? How could it all come down to 4 simple words? But her tone was firm, resolute, and cold. My heart sank, and the house that had always felt like a sanctuary suddenly felt like a courtroom waiting to deliver judgment. I sank into the leather chair in our living room, clutching my coffee cup as if it could somehow anchor me to reality. She sat across from me, perfectly poised, as though we were having a casual discussion rather than the declaration that would destroy my world. "You've changed," she said softly, "and I can't stay in this marriage anymore." I wanted to shout, to beg her to reconsider, to remind her of the life we'd built together, but the words stuck in my throat. Instead, I tried to understand her reasoning. What I heard instead was the language of a legal battle already in progress. Divorce settlement, equitable distribution of property, joint investments, retirement accounts, and possibly even my pension. At my age, the stakes are high, especially after 40 years of marriage. Her words hit me like a punch. I had spent my life planning retirement, assuming my spouse and I would navigate our golden years together, and now everything was at risk. My children would be involved, the family business we had nurtured together could be divided, and the home I'd poured decades of work into could be claimed as hers in part or whole. "I don't understand," I managed to say. "After everything, why now?" She didn't answer immediately. Instead, she took a deep breath and said words I will never forget. "I want what's legally mine, and I want my freedom." That was it. I realized then that this wasn't about emotion. It was about the law, about assets, about control. And she had already started planning. I could see it in her eyes, the meticulous calculation of someone who had already consulted a divorce attorney. The next day, I scheduled my own lawyer consultation. Sitting across from a seasoned divorce attorney in a downtown office, I tried to process everything. The lawyer, a sharp, gray-haired woman named Karen, flipped through the notes I had taken while she listened patiently. "Mr. Johnson, at this stage, the first thing you need to understand is the scope of potential claims: alimony, equitable distribution of property, joint investments, retirement accounts, and possibly even your pension. At your age, the stakes are high, especially after 40 years of marriage." Her words hit me like a punch. I had spent my life planning retirement, assuming my spouse and I would navigate our golden years together, and now everything was at risk. My children would be involved, the family business we had nurtured together could be divided, and the home I'd poured decades of work into could be claimed as hers in part or whole. Even at home, the atmosphere had changed. My wife spoke in terms of fair division and legal entitlements, avoiding any mention of love, loyalty, or shared history. Our children, sensing tension, tiptoed around the subject. Every meal, every casual conversation felt like navigating a minefield. One evening, as I sat alone in the study reviewing financial documents, the reality hit me like a cold wave. 40 years of marriage, gone in an instant. The pension I had counted on, the home I loved, the security I had assumed, all could be dismantled by lawyers, courts, and legal strategy. I felt a strange mixture of fear, anger, and disbelief. But beneath it all, a resolve began to form. I wasn't going to let decades of hard work be taken without a fight. If the law was going to be involved, I would meet it head on. I would protect my home, my investments, my dignity, and the retirement my life had earned. And most importantly, I would ensure that even in this legal battle, justice, not vengeance, would guide me. As I looked out of the study window, the city lights of my hometown flickering in the distance, I whispered to myself, "This isn't over, not by a long shot." And that was when I knew that the next few months would define the rest of my life, financially, legally, and emotionally. The game had changed. Divorce was no longer just a word. It was a legal battlefield, and I was determined to emerge intact. I thought we were partners for life, but the divorce papers she had already prepared would prove otherwise.
I thought we could talk it out, but the moment I sat in that lawyer's office, I realized this was a legal war, not a conversation. The morning was overcast, with gray clouds hanging low over the city. I drove to Karen's downtown office, my mind spinning with calculations, fears, and what-ifs. 40 years of marriage didn't prepare anyone for this. Even after decades of shared life, I felt like a newcomer to a battlefield I had never signed up for. Karen's office was sleek, modern, and intimidatingly professional. Leather chairs, polished wooden desks, and law books lined the walls. I took a seat across from her, clutching a manila folder with financial statements, property deeds, and investment summaries. "Mr. Johnson," she began, her voice calm but firm, "I understand this is emotionally devastating, but we have to separate feelings from facts. You are entering what the law calls dissolution of marriage. At your stage, 65, you have a significant amount at risk: your home, retirement accounts, investments, and possibly your pension." I nodded, swallowing hard. Pension. That word alone made my chest tighten. I had worked for decades, carefully planning my retirement. I never imagined my spouse could claim a portion. But Karen made it clear. In California, long-term marriages like ours often result in equitable distribution. "Equitable," I repeated, "meaning half?" "Potentially, yes," Karen said. "Courts aim for fairness, but that can mean a large portion of your assets are considered marital property. That includes your primary residence, your savings, brokerage accounts, and any other assets acquired during the marriage." I felt the room tilt slightly. My house, my sanctuary, the place we raised our kids, could be divided like a commodity in a courtroom. The life I had spent building suddenly felt like a ledger of dollars and cents. Karen continued, laying out the possible legal battles ahead. Alimony claims. My wife could request spousal support based on 40 years of marriage and my retirement income. Property division. The house, cars, bank accounts, and investments all could be subject to legal negotiation. Business interests. If we had any joint ventures or investment properties, those too could be claimed. Pension and retirement accounts. Long-term contributions might be considered marital assets. I listened, heart pounding, as she outlined strategies to protect what I had legally. It was like studying for a high-stakes exam, one where failure could mean losing everything. "Karen," I said, my voice shaking slightly, "I thought after 40 years we'd be together until the end. Now, she's treating this like a business transaction." "That's often the reality, especially when someone has already consulted a lawyer. You need to prepare for negotiations, valuations, and, if necessary, litigation." I left the office feeling simultaneously enlightened and terrified. My wife hadn't just said 4 words that destroyed our marriage. She had already initiated a strategy to claim her share of 40 years of assets. The realization hit me like a hammer. I had to act fast, or I would risk losing more than just property. I could lose my financial independence. Over the next week, I met with accountants and financial advisors, calculating potential settlement scenarios. Every number, every asset, every account became a point of tension. The equity in the house, the stocks, the retirement funds, even life insurance policies, all needed scrutiny. I began documenting everything: past contributions, mortgage payments, investment deposits, and legal ownership papers. One afternoon, as I sat in the study reviewing statements, I realized the emotional weight was becoming almost physical. Every decision my wife had made to consult lawyers, plan strategically, and prepare documents felt like a personal betrayal. even though legally it was simply exercising her rights. Yet, amid the fear, a plan started forming. I wasn't helpless. I had decades of experience managing assets, negotiating contracts, and solving complex problems. This was just another problem, but with much higher stakes. Protecting my home, retirement, and dignity would require strategy, patience, and the right legal team. By the end of the week, I had drafted a preliminary list of priorities. Secure legal representation specializing in high net worth divorce. Document every financial transaction and asset to prove ownership and contributions. Review the mortgage, retirement accounts, and investment portfolios with professional advisors. Prepare emotionally for courtroom proceedings, negotiations, and potentially contentious hearings. I realized that while this was deeply personal, it had become a legal and financial battlefield. The woman I had shared 40 years with was now my opponent in the eyes of the law. And if I didn't approach this methodically, I could lose not just assets, but the security I had worked my entire life to build.
I couldn't believe it. After all these years, the house I thought was ours wasn't even in my name. The morning sunlight fell lazily across the wooden floors of our living room. I sat at the edge of the sofa, staring at the polished hardwood, my mind racing. 40 years of mortgage payments, renovations, countless family dinners, birthdays, Christmases, every memory tied to these walls. But legally, it wasn't mine, not even a shred of it. Karen, my divorce attorney, had been crystal clear in our last meeting. Ownership matters, and in your case, it could mean the difference between keeping the house or losing it entirely. I remember driving to our office earlier that week. The streets were quiet, yet the weight in my chest made it feel like the city was a battlefield. Karen greeted me with her usual calm professionalism, papers neatly stacked on her desk. "Mr. Johnson," she said, adjusting her glasses, "I reviewed the property records. There's a glaring issue. You aren't listed as the owner on the deed of your primary residence. Your spouse signed all documents in her name decades ago. That puts you at a disadvantage in any divorce settlement regarding the house." The words hit me harder than I expected. I had assumed ownership. I had invested time, money, sweat, and love into that home. But legally, the documents told a different story. She had always said, "Don't worry, it's our home." And I believed her. Karen continued, her voice unwavering. "We can fight, but you'll need strong evidence, proof of contributions, mortgage payments, maintenance costs, renovations. Every single dollar counts." I left her office feeling a mix of disbelief and determination. Over the next few days, I dug through old bank statements, mortgage documents, and receipts for every improvement we had made. Kitchen remodels, new roofs, landscaping, even the fancy deck my grandchildren loved. They all became pieces of evidence in a war I hadn't asked for. Late one evening, I sat with the documents spread across the dining table, the light from the chandelier casting sharp shadows on the stacks of paper. My hands shook slightly, not from age, but from the sheer magnitude of betrayal. 40 years of life together, and suddenly, every memory was weighed against legal definitions, property deeds, and divorce laws. Karen suggested one strategic move. Hire a forensic accountant to track every mortgage payment and expense I had contributed. Courts respond to numbers, facts, hard evidence. I nodded, realizing that my life's work, my financial prudence, careful savings, and dedication was now my weapon. The battle ahead wasn't about emotion, it was about preparation, documentation, and strategy. Days turned to nights as I gathered statements from banks, investment portfolios, and property tax records. I even contacted contractors for old receipts of renovations. Each document was a thread in the tapestry I would present in court, a story of a man who had invested decades into a home he believed was legally his. One quiet evening, as I reviewed the final stack of evidence, my phone buzzed.
It was Karen. "We're ready to file the first motions. The judge will consider your contributions and will argue for equitable distribution. But be prepared, this will be contentious." I leaned back in my chair, letting out a long sigh. The house, once a sanctuary of comfort, had become the symbol of betrayal. And yet, there was a flicker of hope. With the right legal team, with careful strategy, I could turn years of oversight into proof of ownership by contribution. I looked around the living room, the pictures on the mantel, the Christmas tree ornaments, my grandchildren's drawings on the fridge. Every memory was now part of the legal story I was building. They were my allies, silent witnesses to a life invested in love and labor. I realized that the home I had thought was mine for 40 years could slip through my fingers in a courtroom, and I had only weeks to prove it was truly mine.
I never imagined that asking for fairness would feel like walking into a battlefield. The next morning, the sun had barely risen when I sat at the kitchen table with my coffee, staring at the pile of legal documents Karen had prepared. The papers detailed the alimony request my wife had submitted, demanding a monthly sum that seemed more like a punishment than support. After 40 years of marriage, I knew the law could favor her, especially since she had documented minimal income during our marriage. But I also knew my own financial situation had to be protected. Retirement savings, investments, and the home I had spent decades improving were all at stake. Karen's voice echoed in my head. "Mr. Johnson, alimony is calculated based on lifestyle, contribution, and need. But if we present a strong case showing your contributions and the joint wealth you accumulated, we can fight for a fair settlement." I could still hear her on the phone the night before, outlining the strategy. The first step, collect detailed financial records, bank accounts, retirement statements, investment growth over the years. Every paycheck, every dividend, every property tax payment I'd made had to be documented. It felt like reliving my entire life, but this time under a magnifying glass. The day I went to Karen's office, the tension in the air was palpable. Divorce lawyers, paralegals, and clients moving in and out, everything felt heightened, dramatic, almost cinematic. I wasn't just fighting for money, I was fighting for respect, for the acknowledgement that my life's work was not up for grabs. "Mr. Johnson," Karen began as I sat down, "we're ready to file the first motion challenging her alimony demand. We'll argue that the requested amount is excessive and doesn't reflect equitable distribution. Courts respect facts and evidence, and we have plenty." I nodded, trying to absorb the weight of her words. Plenty. I wondered if I could actually quantify 40 years of shared life, hard work, and silent sacrifices into charts and graphs and spreadsheets. But Karen had a point. Law is literal. Numbers speak louder than emotions in a courtroom. As we prepared the documents, I realized how much my life had changed over these few weeks. Breakfast no longer included small talk with my spouse about grocery lists or grandchildren. Evenings weren't spent discussing dinner plans or watching old sitcoms. My life had become a meticulous documentation of finances and memories, all to protect myself from a system that could be manipulated. Karen handed me a folder thick with statements and invoices. "This is your arsenal, Mr. Johnson," she said, her tone firm but reassuring. "These numbers will tell your story better than any argument ever could." The tension escalated the following week when I received a notice from my wife's attorney, a counter-motion threatening a full-scale court battle. They claimed that I had underreported certain investments and that the lifestyle I enjoyed during our marriage justified higher alimony. My stomach sank. I had nothing to hide, yet the accusation felt like a punch to the gut. I called Karen immediately. "This isn't just about fairness anymore. They're trying to intimidate me." Karen was calm. That's standard in high-net-worth divorce cases. They'll throw everything at you, hoping you'll settle out of fear. We stay factual, we stay prepared, and we let the law do its work. Days turned into late nights of double-checking every statement, every contribution, every expense I'd made. My attorney's office became a second home. Paralegals called with updates, questions about missing invoices, and requests for notarized statements. I felt like a soldier preparing for battle, each document a shield against a barrage of legal attacks. Then came the first pre-trial mediation. Sitting across from my wife, I felt a mix of disbelief and sorrow. 40 years of marriage had shrunk into a negotiation table filled with spreadsheets and charts. She looked calm, even smug, as her attorney detailed the alimony she demanded. I clutched my folder of evidence, feeling the weight of decades pressing down on me. Karen whispered, "Stay composed. Let the facts speak. This is your advantage." The mediator asked questions, challenged figures, and demanded explanations. I answered carefully, presenting proof of my contributions, evidence of joint assets, and the logic behind a fair alimony settlement. Each number, each documented payment, each verified investment slowly began to shift the negotiation. By the end of the session, there was a tangible shift. My wife's attorney looked frustrated, while Karen gave me a subtle nod. The battle was far from over, but the first blow had been struck. I left the office exhausted, but cautiously optimistic. Driving home, I looked at the house, the home that I had fought so hard to claim, the home where memories of my family's laughter and milestones were etched into every wall. It wasn't just about money anymore. It was about principle, legacy, and respect. I realized that this battle over alimony was only the beginning. My wife's next move could threaten everything I had built, and I had no idea how far she was willing to go.
I thought I knew what home meant, until I realized it could be torn from me with the stroke of a pen. The next week, the focus shifted from alimony to property division. After 40 years of marriage, every asset we owned seemed to carry its own history, memories, and weight. Yet now, each house, each investment, each car became a potential weapon in a legal war. Karen had warned me, property division is where many divorces get messy, especially when one spouse believes entitlement outweighs fairness. Our first meeting about property division took place in her downtown office. Legal pads, laptops, and financial statements spread across the table like an arsenal of evidence. I had thought we had joint ownership over the family home, our vacation cabin in the mountains, and even the classic cars my wife and I had collected over decades. But her attorney argued otherwise. According to documents I had never seen, several properties were technically under her name, or so they claimed. "Mr. Johnson," Karen said firmly, "we'll challenge the ownership. The evidence we gathered shows that these were joint investments, and the title should reflect the years of financial contribution you made." It felt surreal, fighting for what I believed was mine. Not just legally, but emotionally. This wasn't just money, it was the tangible proof of a lifetime built together. As Karen outlined our strategy, I realized the complexity. Home appraisals, mortgage payment histories, utility bills, renovation receipts, even property tax statements would be scrutinized. Every small contribution mattered. That afternoon, I began collecting every document I could find. Old bank statements, canceled checks, and home improvement invoices were organized chronologically. Each piece of paper was a reminder of years spent building a life together. At times, I caught myself staring at photographs of family events in those very homes, wondering how they could be reduced to numbers on a spreadsheet. The mediation session was intense. My wife sat across the table, composed, her attorney whispering in her ear, occasionally glancing toward me with an almost accusatory stare. We are willing to divide assets equitably, but both parties need to substantiate ownership and contributions. When Karen presented my evidence of financial input, mortgage payments, joint savings used for renovations, and decades of investment growth, the tide began to turn. I could see her attorney's subtle frustration, while my wife's calm demeanor showed cracks. The mediator probed deeper, asking about specific investments and trusts that had been quietly accumulating over the years. At one point, my wife spoke up, her voice measured but tinged with bitterness. He might have contributed money, but the emotional labor, the sacrifices I made for this family, they count too. I looked at her and understood the sentiment, yet I also knew that sacrifices alone did not transfer property ownership. Karen leaned over and whispered, "Stick to facts. Memories won't win this fight. Documentation will." The hours stretched on. Each counterpoint, each disputed number felt like a chess move. I was no stranger to strategy. I had spent a lifetime engineering systems, analyzing risks, and finding solutions. This, however, was a system I couldn't fully control. Each document, each argument could be challenged, twisted, or ignored. After several sessions, we reached a tentative agreement for partial recognition of joint ownership on some properties, though disputes remained over others, especially the family home and vacation cabin. The tension was exhausting. The thought that someone I had trusted for decades could challenge my right to what I helped build was painful. Yet the legal process was impartial. Numbers and facts would decide, not emotions. Driving home that evening, I reflected on how drastically my life had changed. Breakfasts, previously casual and quiet, were now replaced with review of legal statements. Evenings weren't spent sharing memories or watching old movies, but organizing documents and preparing for upcoming court appearances. Yet amidst the exhaustion, there was a glimmer of control. I was fighting back, reclaiming what was rightfully mine, step by step. I thought the hardest part was over, but when the judge called for the first hearing, I realized the fight for my own home had only just begun, and my wife had one shocking card left to play.
I walked into the courtroom expecting formality, but I wasn't prepared for the storm that hit the moment she stood to speak. The first court hearing was scheduled for a crisp Tuesday morning. The courthouse loomed over the city street like a fortress of stone, its steps worn by decades of people seeking justice, protection, or revenge. I adjusted my tie, straightened my blazer, and clutched the thick folder of evidence Karen had meticulously prepared. Every page contained a piece of my life. Mortgages paid, investments contributed, renovations overseen, proof of my decades-long commitment to the family and its assets. Inside the courtroom, the air was dense with anticipation. Lawyers whispered strategy to clients, clerks moved with methodical efficiency, and judges presided over the proceedings with a calm yet commanding presence. My wife sat across from me, her composure absolute, but her eyes betrayed a flicker of tension. I realized then that the legal battle wasn't just about property. It was a confrontation of wills, decades of shared history now dissected under fluorescent courtroom lights. Judge Reynolds called the session to order. "We are here today to hear the case of Johnson versus Johnson regarding divorce settlement and property division." The gavel struck, reverberating like a drumbeat of finality. My stomach tightened, but Karen's reassuring nod reminded me I was not alone. My wife's attorney began, outlining claims that every property in question was either solely or predominantly hers. Emotional investment, household management, and decades of caregiving should not be overlooked, he said. He spoke persuasively, weaving personal history into legal claims, a tactic designed to evoke empathy while subtly challenging the documentation we had presented. When it was our turn, Karen rose confidently. "Your Honor, the evidence clearly demonstrates joint financial contributions and shared ownership over all contested properties. The documents provided, including bank statements, mortgage records, and joint investment statements, substantiate my client's claim." She presented charts, graphs, and timelines, each meticulously cross-referenced with receipts and legal documents. I could see the judge's eyes scanning, analyzing, and nodding subtly at key points. The difference between emotional arguments and factual evidence was stark, and it felt like a tide beginning to shift in our favor. Then came the most intense moment of the morning: witness testimonies. Family friends, accountants, and contractors who had worked on our homes took the stand. Each recounted conversations, payments, and agreements they had observed over decades. Some shared anecdotes that painted me as the diligent, responsible partner who consistently contributed to property maintenance and financial decisions. Others described my wife's input, acknowledging her efforts while confirming that major financial decisions were joint. The courtroom was a charged atmosphere. Every whispered conversation, every subtle glance felt magnified. I noticed my wife's hands tightening around her folder. Her usually calm demeanor faltered as evidence contradicted her claims. When cross-examination began, tensions escalated further. Karen's questions were precise, slicing through layers of ambiguity. "Did you witness Mr. Johnson making mortgage payments and funding renovations personally?" she asked one witness. "Yes," came the reply, unequivocal and firm. Finally, it was my moment to speak. Standing up, I felt a mix of nervousness and determination. I spoke slowly, deliberately, recounting my financial contributions, the labor of years spent maintaining properties, and the careful planning behind our joint investments. I avoided anger, though inside I seethed with frustration. The courtroom demanded composure, and composure would win. Judge Reynolds leaned forward, eyes narrowing thoughtfully. "I appreciate the thorough documentation and the clarity of your statements, Mr. Johnson. The court will take all evidence under careful consideration." As the session ended, Karen whispered, "You did well. The documentation and witnesses make a compelling case. We've established a solid foundation for the next stage, negotiation or trial." Outside the courtroom, the city felt quieter than usual, almost reflective. I stepped onto the steps, inhaling deeply, feeling both exhausted and strangely empowered. The legal fight was far from over, but the first battle had been won in strategy and preparation. For the first time in weeks, I allowed myself a moment of hope. But just as I thought the worst was behind me, my wife revealed she had secretly transferred one of our most valuable properties, and it would take everything in our legal arsenal to reclaim it.
I thought I knew every corner of our shared life, but the moment I discovered the deed, my heart sank like a stone into a dark abyss. It was a quiet Thursday morning when Karen called me with the news. Her voice, usually calm and reassuring, held an unmistakable edge of urgency. "There's something you need to see," she said. "It's regarding the Maplewood estate." I felt a knot in my stomach. The Maplewood property had always been one of our most valuable assets, a spacious house with panoramic views, purchased jointly after decades of saving. Every renovation, every mortgage payment, every improvement had been a shared effort, or so I believed. When I arrived at Karen's office, she laid the documents on her polished oak desk. My eyes immediately focused on a transfer deed I had never seen before. My hands trembled slightly as I read the lines, disbelief coursing through me. "Property transfer effective April 12, 2025, from joint ownership to Mrs. Johnson exclusively." I swallowed hard. "She did this without telling me?" I whispered, barely able to form the words. Karen nodded gravely. "It appears she initiated the transfer secretly, using signatures forged or backdated. If this holds, we're facing an uphill battle. This is no longer just a divorce settlement. It's a case of potential fraud and property misappropriation." I sank into the leather chair, feeling decades of shared memories and hard-earned investments slipping through my fingers. How could the woman I trusted for 40 years act with such duplicity? How had I missed the signs? We spent the next few hours dissecting every document, every signature, every date. Karen's experience in family law and property disputes became my lifeline. She pointed out loopholes, potential claims, and ways to challenge the deed legally. "The first step," she explained, "is to establish evidence that the transfer was not authorized and possibly fraudulent.
We need proof that you never consented to this and that your signature may have been manipulated." I nodded, determination replacing despair. 40 years of life, work, and sacrifices could not be undone by a single act of betrayal. My mind raced through possibilities: forensic handwriting analysis, financial audits, and consultation with property law experts. Every step had to be meticulously planned. The smallest misstep could cost me the Maplewood estate. Later that day, Karen arranged for a private investigator to review the property records and past bank transactions. We needed a timeline of payments, renovations, and decisions to demonstrate my continuous contribution. Every check, every receipt, every correspondence mattered. As the investigation unfolded, I realized just how sophisticated the plan had been. The transfer deed was filed quietly at the county office, with minimal oversight, assuming I would never notice until the divorce proceedings left me powerless. My mind reeled at the audacity, but I refused to be a passive victim. The legal team prepared a motion to challenge the transfer immediately. Karen emphasized the importance of acting swiftly. If we wait, she could sell or leverage the property, complicating recovery. Speed and precision are our allies. That evening, I sat alone in the Maplewood living room, the dim light filtering through the blinds. Each photograph on the wall, each piece of furniture, every corner of the home reminded me of decades of shared life. But now, these memories were tainted by betrayal. My hands clutched the armrest as a single thought consumed me: justice must be served. I also thought of the upcoming courtroom confrontation. The next hearing would not just be about divorce. It would involve challenging this hidden transfer, proving my contributions, and exposing the potential fraud. The stakes were higher than ever, and I knew the media and legal ads targeting high-value property disputes would make the courtroom a pressure cooker. Just as I prepared to file the challenge, a letter arrived from her attorney. Inside was a shocking claim that threatened to destroy every legal strategy I had meticulously prepared.
I thought the hidden deed was bad, but nothing prepared me for the bombshell her lawyer dropped in my mailbox. The morning started like any other, but my phone buzzed relentlessly with notifications from Karen, my divorce attorney. She had called an urgent meeting for 10 a.m., insisting I see the letter in person. As I walked into her office, my heart pounded like it was announcing a trial before the trial had even begun. Karen handed me a thick envelope, its edges crisp and formal. The letterhead screamed sophistication and authority: Johnson & Associates, Family Law Division. I tore it open carefully, bracing myself. Inside, a single-page outlined claims that sent chills down my spine. Mr. Thompson's contributions to the Maplewood estate are disputed. Furthermore, we allege that any financial input from him was conditional and non-binding, and that the property transferred to Mrs. Johnson is fully legal and enforceable. Any attempts to challenge this transfer will be met with a counterclaim for defamation, harassment, and intentional interference with property rights. I blinked, stunned. My decades of investment, mortgage payments, renovations, and shared responsibility now supposedly non-binding? My mouth went dry. Karen leaned forward, her eyes sharp, dissecting every line. "They're trying to intimidate you before the court even sees the facts," she said. "This is a classic legal maneuver to scare older clients into compliance or delay." I could feel anger bubbling up, but I forced myself to remain calm. 40 years of marriage, decades of shared sacrifices, and now a divorce coupled with an attempt to strip me of property? This was bigger than personal betrayal. It was a war of wills, finances, and legal expertise. Karen quickly outlined our counter-strategy. First, we would gather irrefutable evidence: bank statements, mortgage records, tax documents, and receipts for every home improvement. Second, we would obtain affidavits from neighbors and contractors confirming that my contributions were direct and substantial. Third, the forensic handwriting analyst would testify that any alleged signature of mine on documents I never signed could not be authentic. As we spoke, my mind raced through potential courtroom scenes. I imagined her attorney, smug and confident, trying to paint me as forgetful or manipulative, an elderly man incapable of understanding legal documents. But I refused to let decades of life and careful financial planning be dismissed. Karen suggested another tactic, a preemptive motion to freeze any property transactions. She said, if she tries to sell Maplewood or leverage it for loans, we stop it before it happens. Timing is everything. Leaving her office, I felt a mix of dread and determination. I knew this fight would be long, grueling, and emotionally draining, but it was necessary. I had a legal right to protect the property I helped build and a moral right to assert that betrayal could not erase decades of loyalty and shared effort. Back home, I began compiling documents for Karen, old mortgage statements, canceled checks, renovation receipts, and photographs of improvements. Each document was a small piece of the puzzle, proof that every penny and hour I had invested mattered. As the week progressed, Karen and her team drafted motions, consulted with property law experts, and scheduled the first hearing. Meanwhile, my ex-wife's lawyer's letter haunted me. Its tone was not just aggressive, it was calculated, designed to test my resolve and intimidate a man who had spent his life trusting the bonds of marriage.
Just when I thought I had braced myself, the county recorder's office dropped a bombshell that made my stomach sink. Maplewood was partially gone before I even knew it. It was late Tuesday morning when I received a phone call from the county recorder's office. The voice on the line was polite, professional, but the words that followed made my hands shake. Mr. Thompson, it appears there is a deed filed transferring a portion of Maplewood estate to a third-party trust. Are you aware of this? I froze. My heart pounded as I realized this was not a clerical error. It was deliberate. Someone had moved quickly, filing paperwork I never signed, granting partial ownership to a mysterious entity. My mind raced. Who authorized this? My ex-wife? Her lawyer? Or someone else entirely? I immediately called Karen. Her voice, calm but firm, carried the weight of urgency. We need to get certified copies of that deed immediately and file an emergency injunction. If we don't, any future transaction could be legally valid. By the time I arrived at her office, the team had already pulled the county records. The deed, dated 3 weeks earlier, listed Maplewood's West Wing, the part where the library, study, and guest quarters were located, as transferred to Maplewood Family Trust with no mention of me as a co-owner. Karen's expression was serious. This is an aggressive move, Mr. Thompson. They're trying to isolate the asset, reduce your influence, and make it harder for you to reclaim what's rightfully yours. Legally, it's still contestable, but timing is critical. We discussed strategies immediately. The first step was filing a motion to freeze the property. Second, we would subpoena any communications related to the creation of the trust, including emails, signed documents, and notarized papers. Third, we needed affidavits from anyone who had witnessed the deed's preparation or filing. As I drove home, the weight of betrayal pressed heavily on my chest. 40 years of marriage, decades of shared sacrifices, and now my own home, my legacy, was being stripped away in real time. But I refused to let despair take over. That evening, I sat in the study of Maplewood, flipping through old family photographs. Images of birthday celebrations, family dinners, and holiday gatherings flashed across the pages. I could feel the emotional ties to every corner of the house. My father's workshop, the kitchen where I had taught my children to cook, even the garden that had taken years to cultivate. It was all at risk. Karen called again with an update. The injunction has been filed. It won't stop everything immediately, but it prevents any sales or transfers until the court hears the case. You're protected for now, but we need evidence ready for the hearing. Start compiling everything: receipts, correspondence, witness statements, even photos of renovations. I spent the next days combing through decades of records. Mortgage statements from the early 80s, canceled checks for roof repairs, invoices for new plumbing, and photographs of landscaping projects. Every piece of evidence painted a clear picture. I had been an equal partner in building Maplewood, not just financially, but emotionally. The next call from Karen was more urgent. Mr. Thompson, your ex-wife's legal team just filed a motion to dismiss your claim, arguing that your contributions were non-binding gifts. They're trying to frame decades of effort as voluntary generosity. I could feel the anger rising, but I focused on strategy. I said, we'll fight this. Every dollar, every signature, every document counts. We have proof. The first court date was scheduled for the following week. I felt a mix of dread and determination, dread for the confrontation, but determination to reclaim what was mine. My lawyer reassured me that the case had strong merit and that the court would look closely at the documented history of contributions. Then, just before the hearing, a handwritten note slipped under my door changed everything. My ex-wife had secretly met with an unknown attorney, planning a move that could leave me completely out of Maplewood.
I never expected a single piece of paper to hit my doormat and turn everything I thought I knew about my marriage upside down. It was early Thursday morning when I noticed the small envelope tucked beneath the welcome mat. Its presence was subtle, almost casual, but the handwriting, tight, precise, unmistakably hers, made my pulse quicken. The envelope was unmarked. No return address, nothing to hint at its origin, except my ex-wife's signature-style scrawl. With a deep breath, I tore it open. Inside was a single folded sheet of paper, the words written in black ink so deliberately they practically leapt off the page. You think Maplewood is secure? You think the past 40 years mean anything legally? I've met with an attorney you've never heard of. He knows ways to make your claims irrelevant. Be prepared. The note was succinct, but devastating. Every line carried the weight of a threat wrapped in legalese. She wasn't just challenging me. She was planning a calculated maneuver designed to strip me of control. My heart sank as I read the last words repeatedly. Be prepared. I immediately called Karen, my voice a mixture of disbelief and urgency. Karen, I just received a note from her. She's met with another lawyer, someone completely off our radar. I think she's plotting to invalidate my claim to Maplewood. Karen's tone was calm but firm. Mr. Thompson, this is exactly why we always prepare for contingencies. The injunction protects you for now, but we need to know who she's consulting and what strategies she's discussing. I'll file a motion to compel disclosure. Legally, she can't hide her legal counsel's involvement if it affects the property dispute. The morning passed in a blur. I combed through files, receipts, and photographs once again, confirming every piece of evidence we had to support my claim. Every renovation, every mortgage payment, every utility bill, proof of decades of partnership and personal investment. Yet the note haunted me. It was more than a warning. It was psychological warfare. By mid-afternoon, Karen called with an update. I've started tracing her contacts. It seems she's consulting an estate law specialist out of San Francisco. We can subpoena emails and phone records to uncover communications relevant to Maplewood. Even with legal action underway, the emotional weight was heavy. 40 years of marriage had built trust, stability, and mutual reliance, and now the foundation felt as though it were crumbling. I walked through Maplewood, touching the surfaces of rooms I had helped create, the walls echoing memories of birthdays, Thanksgiving dinners, and quiet Sunday mornings. The familiar creak of the wooden floors beneath my feet reminded me of time's relentless march and how quickly security could be threatened. That evening, I called my eldest son, Michael. His voice, steady and concerned, reminded me that I wasn't alone. Dad, whatever she's planning, we'll help. You've built Maplewood with your blood, sweat, and decades of hard work. That can't just vanish. Despite reassurance, the impact of the note lingered. It had introduced an unknown variable into an already tense legal struggle,
forcing me to question not just my ex-wife's intentions, but the entire timeline of events leading to this confrontation. Karen emphasized preparation. This note, as unsettling as it is, works in our favor. It proves intent and forethought. The court will see it as part of her aggressive strategy to bypass legal procedures. Document everything, Mr. Thompson, every phone call, every email, every handwritten note. Every detail strengthens our case. The next days were a whirlwind of phone calls, document gathering, and drafting supplemental affidavits. My life, once quiet and orderly in retirement, was now filled with legal deadlines, strategy meetings, and the constant hum of uncertainty. Each day, the handwritten warning replayed in my mind like a shadow across Maplewood's pristine floors. Then, late one night, I discovered a hidden clause in the original deed, something so unexpected it threatened to give her total control over Maplewood if I didn't act immediately.
I always thought I knew every corner of Maplewood, but one late-night discovery proved how little I really understood about its legal foundations. It was after midnight when I returned to Maplewood from yet another meeting with Karen. The house was silent, the only sound the soft ticking of the grandfather clock in the living room. I carried a stack of old documents, deeds, mortgage papers, and legal correspondence, hoping to review them one last time before tomorrow's court filing. As I flipped through the original deed from 45 years ago, something unusual caught my eye. Buried in the fine print, in a section titled Ownership Contingencies, was a clause I had never noticed. In the event of dissolution of marriage, the property may revert to the spouse listed as primary owner, provided no legal claims have been registered within 30 days. My blood ran cold. That meant if my ex-wife had been meticulous, and the note suggested she was, she could claim Maplewood as solely hers if she acted fast. 40 years of shared memories, renovations, and financial investments could be overridden by a single legal technicality. I immediately called Karen. Karen, I found something in the original deed, a contingency clause. She could technically seize Maplewood if she plays this right. Karen's voice was calm but sharp. Mr. Thompson, this is serious but not insurmountable. This clause exists, but there are precedents where courts have ruled in favor of equitable ownership in divorce proceedings. We need to act immediately. I want a motion filed first thing in the morning to prevent any attempt at unilateral transfer. The next day blurred into legal chaos. Karen drafted emergency injunctions, subpoenas, and affidavits referencing the newly discovered clause. Every detail of our decades-long financial and personal investment in Maplewood became critical evidence. Every bank statement, renovation receipt, and shared utility bill suddenly felt like a lifeline to preserving what I had built. Even with the legal preparations, the psychological impact weighed heavily. My ex-wife had been more strategic than I realized. The handwritten warning was no longer just a threat. It was a calculated move in a complex chess game I hadn't fully understood. Late that afternoon, as I met with Karen in her downtown office, she looked over the documents and nodded. We're ready. If she tries to invoke that clause, the court will see the pattern of intentional exclusion and manipulation. The contingency won't help her, but you have to be prepared for aggressive counterclaims. That night, I returned home to Maplewood, walking through each room, touching the walls, imagining the decades of life we had built. The house felt smaller now, more fragile, as if every photograph and every memory were suddenly under siege. I realized then that divorce wasn't just about separating finances or possessions. It was about reclaiming the narrative of a life you thought secure. I spent the night organizing files, preparing notes for court, and mentally rehearsing questions I might face. Every detail mattered. The dates of improvements, the receipts for major appliances, letters from contractors acknowledging my payments, even the handwritten grocery lists that showed shared household responsibilities. In a fight over decades of shared life, even the smallest evidence could tip the scales. By early morning, I had prepared a folder thick with proof of my claim, ready for submission. Karen arrived with a legal team, and we strategized for hours, discussing how to counter potential attacks, anticipating every possible maneuver from my ex-wife's side. Her notes, her meetings with the estate law specialist, and that hidden clause were now part of a larger picture, and we were determined to fight back. Just as we filed the emergency injunction, I received an email from her attorney with a single sentence that made my stomach drop. "We've discovered something in the trust, something that could nullify all your claims if you don't act within 24 hours.
I thought the worst was over until her attorney's email gave me just 24 hours to respond, or everything I'd fought for could vanish. The sun had barely risen when my phone buzzed with another message from Karen. I opened it with a sense of dread, already knowing what it would say. The email from her ex-wife's attorney had a subject line that made my hands tremble. "Immediate action required. Trust clause dispute." Karen's face was tense as I handed her my tablet. "Mr. Thompson, this changes everything," she said calmly but firmly. "They've discovered a clause in the family trust, something that, if filed correctly, could bypass the property contingency we found yesterday. You have exactly 24 hours to respond, or Maplewood could be considered solely hers by the court." I sank into my chair, the weight of the situation pressing on me. 40 years of marriage, memories, financial investments, and personal sacrifices, all on the line because of a single oversight in estate planning. The gravity of the legal labyrinth hit me fully. I had known divorce battles could get nasty, but this felt like navigating a minefield blindfolded. Karen began pacing the office, reviewing the trust document on her tablet. "There's a loophole we can exploit. They claim that certain additions to the trust give her control over property acquired during the marriage, but those additions were made after she filed the initial divorce petition, which could be considered post-divorce manipulation. If we argue that the trust additions are invalid, we can counter their claim effectively." I nodded, trying to steady my nerves. Every word she said sounded reasonable, but my mind kept racing. What if she had already anticipated our move? What if the 24-hour window wasn't just a bluff? The clock ticked mercilessly. Each passing hour brought me closer to potential disaster. I spent the morning compiling evidence, financial statements, property tax records, emails discussing shared investments, and even photographs of renovations. Each piece of proof reinforced our claim. Each one a brick in the wall defending my decades of work and memories. By midday, Karen had drafted a precise legal response, citing precedent cases and detailing how the trust clause could not override my established property rights. She called me over to review the documents. "Everything is here, Mr. Thompson. Every argument we need, every counterpoint, every piece of evidence. You just need to authorize me to file it immediately." My hands hovered over the e-signature prompt. The reality hit me. This document wasn't just words on paper. It was my final defense against losing a lifetime of stability and dignity. I took a deep breath, pressed the button, and felt a flicker of hope. But the day wasn't over. No sooner had we filed our response than my phone rang. It was her attorney, their voice smooth, almost taunting. "Mr. Thompson, I hope you understand the severity of your position. You have 24 hours to reconsider, or we will escalate this matter and seek immediate enforcement of the trust clause. Maplewood could be under her control by this evening."
Karen answered on my behalf, her tone professional and unwavering. "We've filed our response and we are confident it addresses the clause appropriately. Any further threats will be handled through legal channels." I watched, tense and silent, as the minutes dragged by. The morning sunlight slanted through the office windows, casting long shadows across the desk cluttered with legal papers. I realized then that divorce wasn't just about ending a relationship. It was a battle for control, dignity, and justice. Each clause, each loophole, each attorney's move could change everything. Late that afternoon, the court acknowledged receipt of our filing. A small victory, but it felt monumental. Karen's face softened briefly as she said, "Mr. Thompson, the immediate threat is contained. They can no longer enforce the trust clause until the court reviews our submission. We've bought ourselves time." I exhaled, the first real breath of relief in 24 hours. But deep down, I knew the fight wasn't over. Every document, every email, every meeting could escalate this legal war further. And through it all, the clock of my remaining patience ticked relentlessly. That evening, I returned to Maplewood, walking through rooms filled with 40 years of memories. The house was quiet, but my mind was anything but. I reviewed each legal document again, imagining potential counterarguments, anticipating every move her legal team might make next. This wasn't just about property. It was about proving that a lifetime of partnership deserved recognition, even when betrayal loomed. As I locked the front door and turned off the lights, my phone buzzed one last time. An urgent video call notification from her attorney with a single message flashing across the screen. "You won't believe what we just found in the safety deposit box."
I thought I had prepared for everything, until her attorney revealed a secret hidden in the safety deposit box that could ruin everything overnight. The next morning, I barely slept. My mind kept replaying the final words from the previous day. "You won't believe what we just found in the safety deposit box." Karen had insisted that we remain calm, but I felt the tension gnawing at me like a relentless tide. 40 years of marriage, decades of shared investments, and suddenly, every ounce of stability felt fragile. Karen arrived at Maplewood just as the sun broke over the horizon. She carried a thick manila envelope that seemed heavier than its contents. "Mr. Thompson, this is what her attorney claims to have found in the safety deposit box. It's supposed to change the dynamics of your property claim entirely." I took the envelope with trembling hands, trying to steady myself. My pulse raced. What could possibly be in a safety deposit box that she hadn't disclosed all these years? The thought of hidden assets, forged documents, or undisclosed investments made my stomach churn. Karen opened the envelope on the dining room table, revealing a series of bank statements, trust amendments, and legal documents dated within the last 5 years. My eyes immediately focused on one page, a notarized letter that appeared to transfer a significant portion of Maplewood's equity to her name in the event of a divorce. The words seemed to burn on the page. "In the event of dissolution, the undersigned grants full claim to the marital property described herein to Jane Thompson." I felt my chest tighten. My entire strategy for protecting the house, the investments, and my life's work seemed to teeter on a knife's edge. Karen pulled up her laptop and began mapping out a strategy. "We need to file an emergency motion to challenge the validity of these documents. If we act quickly, we can prevent her from using this as leverage in court. I'll draft it, but you'll need to provide a sworn statement detailing your understanding of the house's ownership history and the investments you personally funded." I nodded, swallowing hard. The legal jargon, the deadlines, the threat of losing Maplewood, it all felt overwhelming. But I also felt a renewed determination. 40 years of work, memories, and love weren't going to be undone by last-minute surprises or hidden papers.
By late morning, we had drafted a comprehensive emergency motion. Karen's arguments were precise. The improper notarization, the questionable timing, and the inconsistencies in her claim all formed a strong legal foundation. We planned to file it first thing the next morning, hoping to gain a temporary injunction to freeze the status quo. The day dragged by with agonizing slowness. I reviewed every corner of Maplewood, revisiting rooms where memories of 40 years seemed to echo back at me. The kitchen where we had celebrated anniversaries, the study where investments had been planned, the living room where grandchildren had played. All these spaces reminded me why I couldn't let this legal battle strip me of everything I had built. Evening brought a moment of reflection. I sat on the porch, looking at the sun setting behind the familiar hills. Karen joined me, sipping coffee in silence. "Mr. Thompson," she said softly, "this isn't over, but we have the law on our side. Remember, your decades of investment, both financial and emotional, are well documented. That counts for a lot in court." I felt a sliver of relief, though anxiety still lingered. The safety deposit box had unveiled a secret, but it hadn't broken us. Not yet. Just as I was about to relax, my phone rang with a blocked number. An unfamiliar voice whispered only 3 words, "We know everything."
I thought the worst was behind me until I stepped into the courtroom and saw her smirk, knowing she had one last card up her sleeve. The morning of the hearing arrived with a nervous energy I hadn't felt since my first big business presentation decades ago. Maplewood, my home of 40 years, seemed to pulse with the tension of what was about to unfold. Karen arrived early, briefcase in hand, exuding calm authority that instantly reassured me. "Mr. Thompson, today we put everything on the table," she said. "Stay focused, stick to the facts. Your preparation will speak louder than words." The courthouse loomed over the city like a fortress of justice, its marble pillars reflecting the early sunlight. I could feel the weight of every decision, every investment, every cherished memory pressing on me. 40 years of marriage, all the savings, the house, the retirement funds, everything was now at risk because of a secret she had kept hidden in a safety deposit box. Inside the courtroom, the air was thick with anticipation. Reporters were gathering outside, though cameras weren't allowed in the room, their presence a reminder that this was no ordinary divorce. Her attorney, a sharp woman named Clarissa Monroe, had already arrived, exchanging a knowing smile with my ex-wife, Jane. Her smirk made my stomach twist. Judge Hamilton entered, and the room immediately fell silent. His presence demanded attention, and I reminded myself that no one could intimidate me here. Karen handed me a stock of documents, carefully highlighted evidence showing my decades of financial contributions, property deeds, and the improper notarization of her hidden documents. Clarissa began with a polished statement, emphasizing her client's rightful claim to the house and investments. The words felt like daggers. I clenched my fists under the table, reminding myself to remain calm. Karen was whispering strategies, guiding me when to interject and when to simply observe. When it was my turn, I spoke clearly, recounting the history of Maplewood, my financial contributions, and the timeline of investments. Every number, every bank statement, every signed deed was presented meticulously. I could see the judge nodding occasionally, clearly following the logical thread of our case. Then came the dramatic moment. Clarissa attempted to introduce the safety deposit box documents as evidence. I felt my pulse quicken. This was the moment we had feared. But Karen was prepared. She stood, pointing out the procedural flaws, the improper notarization, and the fact that my wife had attempted to introduce them after the statutory deadline for property claims. The courtroom murmured. Even Jane's confident smirk faltered. Judge Hamilton carefully reviewed both sides, questioning Clarissa about the timing and validity of the documents. Karen's arguments were precise, each word a strategic strike. "Your Honor,
These documents, while notarized, failed to comply with state law regarding safety deposit boxes. They were not executed according to legal standards and cannot supersede existing property rights, she stated firmly. For what felt like hours, the courtroom transformed into a battlefield of legal expertise. Witnesses were called, experts testified, and every piece of evidence was scrutinized. I watched Jane's confidence crumble as the weight of the truth and proper documentation pressed down. Finally, Judge Hamilton leaned back in his chair, folding his hands. I have reviewed all evidence, testimony, and arguments presented by both parties. It is clear that Mr. Thompson has maintained consistent, documented ownership and investment in the property in question. The documents from the safety deposit box are hereby deemed invalid and inadmissible. A wave of relief washed over me. I had anticipated this moment for weeks, but hearing it aloud in the courtroom made the victory tangible. Jane's face fell, her smirk replaced with disbelief. Clarissa whispered something sharply to her, but it was too late. The court had spoken. Karen turned to me, a quiet smile of triumph on her face. We did it. Justice is served. As we left the courthouse, the cool afternoon breeze felt like a cleansing wave. Reporters were waiting outside, and I gave a brief statement. This isn't about winning against a spouse. It's about protecting what's rightfully yours and ensuring fairness under the law. But as we drove away, my phone buzzed with an anonymous text. You may have won today, but the real fight isn't over.
I thought the court had finalized everything. But then came the phone call that changed everything in an instant. The day after the courtroom victory, I woke with a cautious optimism. 40 years of memories, investments, and hard-earned security had been hanging in the balance, and now it felt as if the storm had passed. Yet, as I poured my morning coffee and looked over Maplewood from the kitchen window, a flicker of unease reminded me that battles in life rarely end so neatly. My phone rang just as I was reviewing the final paperwork Karen had left on the dining table. The number was unfamiliar, and a knot formed in my stomach. "Mr. Thompson," a calm professional voice said, "this is Eleanor Davis from Monroe Legal Group. We represent Jane Willis. I have a proposal regarding a settlement you may find unexpected." I set my cup down, gripping it tightly. Karen had warned me that even after a court ruling, attempts at private settlements often surfaced. Still, something in Eleanor's tone suggested this wasn't just a formality. "Go ahead," I said cautiously. "Given the recent court ruling invalidating the safety deposit box documents, our client recognizes the court's decision. However, she is offering a mediated settlement, allowing for partial equity transfer back to her, specifically a portion of the investments made jointly over the last 20 years. This is to avoid prolonged appeals, which could be costly for both parties." I felt a rush of conflicting emotions. Relief that there wouldn't be a drawn-out battle, but anger at the audacity of even suggesting my lifetime of savings could be split again. Karen, who had been listening quietly, raised an eyebrow. "They're trying to negotiate leverage post-verdict. It's a common tactic, but it's optional. You don't have to agree." I thought about Maplewood, the house where Jane and I had shared 40 years of life. I thought about the investments she had never truly contributed to, and the countless hours I had spent building security for our future. My voice was steady but firm. "Thank you, but no. I will not agree to a single penny beyond what the court has decided. The law is clear, and I'm not going to negotiate my lifetime of hard work away." Eleanor paused. "Mr. Thompson, sometimes refusing a settlement leads to legal battles that can drag on for years. Are you sure you want to take that risk?" "Yes," I said, gripping the edge of the counter. "There is no risk, only justice, and I've already won that.
I will not let anyone manipulate me into paying for what is mine." Karen nodded approvingly. "That's the right decision. They may attempt another appeal, but the court record is solid and your documentation is ironclad. Any frivolous litigation would only backfire." The day moved on with a strange mix of triumph and lingering tension. I reviewed all the financial statements once again, ensuring every dollar, every deed, every legal document was in perfect order. Maplewood was mine, my retirement funds intact, and the victory validated the principle I had lived by. Integrity and meticulous preparation triumph over betrayal. Later that evening, as the sun dipped behind the hills and bathed Maplewood in golden light, I reflected on the past 40 years. Marriage, like life, is never perfect. Trust can be broken, and sometimes people you love make choices that seem incomprehensible. But preparation, knowledge, and principled action can reclaim control even in the darkest moments. The phone buzzed again. This time it was a simple text from Karen. "All documents filed and confirmed. Jane has 30 days to decide if she will appeal, but your position is secure. Enjoy your evening. You've earned it." I sank into my favorite armchair, savoring the quiet that had been absent for so long. The house smelled faintly of cedar and polished wood, a comforting reminder of home. My mind drifted to the lessons learned, that loyalty and hard work can be tested, but legal protection and planning are shields no betrayal can breach. I thought of my friends, neighbors, and all the men in my generation who might face similar unexpected challenges late in life. This story wasn't just mine. It was a warning and a guide. Protect your assets, document everything, and never underestimate the importance of competent legal counsel. Just as I set my tea down, a second message appeared on my phone from an unknown number. "You may have won the court, but the real test of your life is about to begin."